Sir, go ahead.
Thank you. I don't think I'll need it. Good afternoon, Madam President and members of the City Council. I'm here today as part of Sunshine Week to encourage you in setting your federal and state legislative priorities to adopt a resolution opposing California Senate Bill 615 and directing your city attorney's office to abandon its sponsorship of the bill. That SB 615 is bad legislation should be reason enough to oppose it. But the fact is, the bill makes San Diego look like it's eager to return to its Enron by the Sea days. At the conclusion of my remarks, I'm going to play for you a recording of the city attorney on the subject of the Soccer City memo that Chris Cate lawfully disclosed. Yes, you heard me correctly, he lawfully disclosed it. Before I get to that, however, I want you to understand how it is that the city attorney's office is getting you into hot water when dealing with public records requests, and why SB 615 looks to me like an attempt to insulate that office from more scrutiny, especially at a time when its leader is straddling both sides of the labor negotiations fence. SB 615 is not in the City Council's best interest. I know that many members of this body in the past have experienced difficulty getting information from the 11th floor, especially when the information requests come from someone viewed unfavorably by that floor. So frustrated were those members that they had to ask surrogates to submit public records requests in order to get the information. Likewise, SB 615 is not in the public's best interest. The proposal has been touted by its sponsor for establishing a meet and confer process that ostensibly would avoid litigation. But that process already exists in the law, is mandatory, and it usually works. If you look at the cases my clients have filed against the city, in pretty much every instance, the city either refused to fully participate in the process or ignored it altogether. SB 615 doesn't get rid of bad behavior by public agencies. It merely gives them more opportunities to engage in that bad behavior and run up the legal bills along the way. Speaking of running up the bills, the CPRA contains a provision that requires the parties to seek a ruling on the merits at the court's earliest convenience. I litigate these cases against plenty of agencies, and I've never seen any law office file more pretrial motions than a city attorney's office, which does nothing but run up the bills. I have lots of examples of your city attorney's office running amok in CPRA lawsuits, but let's talk about one of the latest examples. As you know, I represent a former member of this body, Donna Fry, in a lawsuit over how the city releases its outside lawyers from their conflicts of interest when they turn around and decide to represent private clients against the city. The city attorney's office got the city sued this time because it refused to turn over all the past conflict waivers. After the lawsuit was filed, the city still refused to turn over all the executed waivers, which forced my office to issue a subpoena to one of the outside lawyers. That lawyer turned over the waiver, which is not surprising. What is surprising is that the city attorney's office put Donna to all that expense, an expense that the city will eventually have to cover. As all of you know, Donna submitted a settlement proposal to you about 2 months ago because all she cares about is making sure that the public knows when the city is letting outside lawyers off the hook. That settlement offer was sent to the city clerk and is not confidential because Donna believes the public should know what is going on. Yet the city attorney's office refuses to put the offer on your closed session agenda and refuses to approve anyone else's attempt to put it on the agenda. So Donna's legal bills continue to rise, and you will be the ones publicly judged for allowing them to go sky high and having less money for your constituents later on. The city attorney's office will blame you for doing nothing about it, and there will be nothing in writing to suggest that that office is really to blame. The members of this body, every one of you, is setting yourselves up to be the ideal scapegoats. Which leads me to my next point. There's a bizarre phenomenon that I'm seeing right now concerning the role of advice from the city attorney's office in your decision making. I've heard about this a lot in the last 2+ years from people outside City Hall, and I've observed it myself. Members of this body have publicly stated more than once that you're pursuing a certain policy or not pursuing it based on advice from the city attorney's office. And when the public asks to see the advice, they're told it's confidential. That leads me to believe that the city attorney's office is giving unsolicited advice via confidential memos. If true, this is really bad for you politically, if not altogether illegal. You are the ones who have to face the voters over your policy decisions. If you make a bad call and you did it based on the advice of the city attorney's office, the public should know that you're not to blame. Now, we have a recent example of this very thing. It involves SDSU and Soccer City. Before SDSU West and Soccer City qualified to go on the ballot, there were members of this body who wanted to go through an RFP process to find out from the private sector what could be done with the property. Several of you received input from multiple outside lawyers and other experts on the subject matter, explaining the legal path that the city could easily take if it wanted to try an RFP. The city attorney's office shot it down in a legal memo, a public legal memo, that without citing a single legal authority standing for the proposition that your hands were tied, told you not to go that route. Fortunately, the public got to see that bad legal advice. What the public did not get to see, until the Union Tribune posted it online, was the secret memo that the city attorney's office wrote to you. My clients found out about it when they saw a portion of it quoted in a letter from Soccer City's lawyers. They then made a public records request for the memo and were told they could not see it because it was confidential. I didn't understand how that could be true because it was quoted in the letter, so my clients had me file a lawsuit to get the memo. As soon as the lawsuit was filed, the city attorney promised me that she was going to convene a special meeting of the city council to get the confidentiality lifted. That never happened. Chris, it turns out that you and I have something significant in common, I think. Both of us have been burned by Jerry Braun. The only difference is that after he burned me, the investigation showed no evidence of wrongdoing on my part. You got railroaded. Here's what I think happened. After the city attorney promised me that she was going to ask this body to lift the confidentiality, she found out that the memo had separately been disclosed by someone in her office. I'm pretty sure Jerry Braun was the leak in the Soccer City case because he was the leak in my case. Unfortunately, the city attorney probably didn't learn this until after she made that public statement about someone at City Hall being a traitor and a criminal. Having done so, she needed a fall guy because she knew that if her office did not become the investigator, it would become the investigated. Of course, I did not know this at first. Early during that lawsuit, I sent discovery requests designed to identify whoever disclosed the memo to prove that it rightly belonged in the public domain. On most discovery requests, the city attorney's office puts up a huge fuss. This time, however, the office was unusually and exceptionally cooperative. Now, there's another theory. After the city attorney promised to get this body's permission to remove the memo's confidentiality, somebody asked what would happen if the no longer confidential memo became admissible in city litigation over the SDSU or Soccer City ballot measure. Might the memo hurt the city attorney's chances in court? Though it's possible the city attorney just had second thoughts, I'm not ready to embrace this alternative yet because she would have never promised to ask you to lift the confidentiality if she thought the memo would have hurt her office's chances in court. To me, the better explanation is that someone in her office leaked it. But either way, Chris, you got railroaded, which is bad enough. But then your colleagues made it worse at the urging of the city attorney's office when they approved the closing of the proverbial escape hatch that allowed you to disclose the memo. That escape hatch existed for a good reason. When somebody in the minority believes that the majority is doing something wrong behind closed doors, those in the minority cannot be silenced by the majority, and they have an outlet to blow the whistle. When this body got rid of the escape hatch, you handed over even more power to the city attorney's office. Today, if one of you thinks that that office is giving you bad legal advice, you are now effectively silenced because you cannot get that advice peer-reviewed or crowdsourced. On top of that, the same city attorney's office convinced you in secret to challenge the SDSU West and Soccer City initiatives in court. You lost both. And in the case of Soccer City, the judge recently ruled that the city must pay April Bowling's lawyers more than $300,000 after your lawyers made what the judge himself described as a frivolous argument. Where is the city attorney's memo that persuaded you to file this frivolous, expensive litigation? That's where you find yourself today. You are handcuffed by a city attorney's office that puts tremendous pressure on you not to let the public know You think you're getting bad legal advice. This is an institutional problem. I blame no single lawyer in that department. There are many good lawyers in that office, and I have the privilege of working with them all the time. More transparency would bolster the public's view of their individual work. And that's why you should oppose SB 615. Making it harder for the public to get information will ultimately mean that you will have a harder time getting the information you need to do your job. In sum, I urge you not to go along with something else that's really stupid coming out of your city attorney's office. You are the client, you are the boss, you are in charge. I urge you to act that way. Now here's that recording. As you listen, ask yourself why your city attorney was in favor of removing the confidentiality before she was against it. Or better yet, ask her yourself. This was a voicemail that was left for me.
Hi, Cory. It's Mara Elliott. Just trying to catch you. I'm going to be in a meeting at 1 o'clock, but what we're trying to do, and I told you that I need to get my client's consent, even though there has been an apparent breach, to release this memo, and that's what I intend to do. So I'm trying to get that scheduled for tomorrow before everybody heads out for the holiday weekend. I will keep you posted, and of course, you're welcome to come. So I believe this will be an open session meeting, hopefully tomorrow afternoon. Thanks, Cory. Bye.
That was June 27th or June 28th of 2017. Thank you.
That concludes the public testimony on this item.